Nalini, the very fact is that, at least in this case, religious leaders across faiths have shown unity when it comes to this issue. All of them collectively opposing same-sex marriages.
Well, Sneha, at the end of the day, it's a constitutional question, which is why a 5-judge bench of the Supreme Court has been constituted to hear that. Now, I've been speaking to a lot of petitioners who've been in a lot of anxiety since yesterday evening when the news came out that the judgment's coming today. And what they're saying is that they're cautiously optimistic, keeping in mind that the 5-judge bench has given them a very extensive hearing. The hearings were live streamed. And what they've said is that they are happy that the conversation is happening now. So they're cautiously optimistic about the verdict. But one thing that everybody, the lawyers who've appeared before the Supreme Court, as well as all of the petitioners have said, is that the Supreme Court bench raised some very relevant questions. In fact, there was a point when the centre had argued that the law only recognizes marriage between a biological man and a biological woman, to which the CJI had categorically responded, saying there's no absolute concept of a biological man and a biological woman. So the kind of questions that have come in from the bench have been extremely relevant. They are likely to look into aspects only regarding the Special Marriage Act. They are not going to go into personal laws at all, that has been categorically stated by the Supreme Court during the hearing. So we'll have to see whether or not the ancillary rights will be granted, but we can expect some sort of a judicial pronouncement and maybe a middle ground that the Supreme Court will take, because at the end of the day, it is up to the Parliament to make the applicable laws to ensure that these rights are granted. So all the Supreme Court can do today is give a judicial pronouncement and maybe try and compel the Parliament to act a little bit more expeditiously when it comes to equality and the rights for the LGBTQ community in India.
That's right. Well, even if you were to consider a situation where the Supreme Court, in fact, gives a green signal to same-sex marriages, and this is a very hypothetical sort of a situation, the fact is that there are a plethora of laws that will need to be tweaked, is what Nalini is indicating to us. And that job at the end of the day is that of the governments. We'll talk about that in a moment from now. But all eyes, of course, in the Supreme Court today. Apex Court is going to be, in all likelihood, announcing its verdict on the legal recognition of same-sex marriage. In May, the top court had reserved the judgment on a batch of pleas seeking legal validation for same-sex marriage. The bench that was hearing the pleas comprised of the Chief Justice D.Y. Chandrachud and Justices S.K. Kaul, S.R. Bhatt, Hima Kohli and P.S. Narasimha. In May, the Supreme Court held a marathon hearing after 18 same-sex couples filed petitions before the Supreme Court, seeking recognition of their relationship with the legal and social status of marriage. Now, prior to the pivotal Supreme Court verdict, India Today also spoke to the petitioners in this case, Utkarsh Saxena and Anaya Kotia, who are the petitioners before the Supreme Court seeking legal recognition for same-sex marriage, speak on the Supreme Court judgment. Take a look.
It's a big day. In a few hours from now, we'll know what the Supreme Court has decided and what way they're going to go. What are your thoughts as of now? What are you feeling in this moment?
What are we feeling? I would say, think of all the anxiety you felt before your class 10 board exams and then class 10 board results and 12th board exams and board results, and put it all together. And I'm still more anxious and nervous right now.
Yeah, I think it's been a long wait. Finally it's going to be full circle soon tomorrow. So really looking forward to it.
So, Utkarsh, you're also one of the lawyers who's been working very closely in the case, who appears regularly before the Supreme Court. So can you just take our viewers through few final legal points about what the Supreme Court's expected to decide upon and what all they will be looking into in this judgment?
Sure. So at the outset, the Supreme Court limited the ambit of this litigation to only the secular laws. So personal laws, Hindu Marriage Act, Muslim Marriage Act, etc., are not a part of this litigation. It's only about secular laws and the Special Marriage Act. And the big question is, can you interpret the Special Marriage Act in a way that's agnostic of gender and sexual orientation, such that any two persons, irrespective of their sexual identity, are allowed to get married under the law? And that's basically our petition. There are some concerns about, does that mean that when you take away gendered words, that you take away gendered protections, right? So one of the concerns was that women have special provisions for divorce and maintenance. Do those go away because you're making them gender neutral? And our response to that was, no, you don't, because We're only challenging those gender provisions that are exclusionary of queer couples. Some of these are specifically designed for heterosexual relationships, for men qua men, for women qua men, and therefore they don't concern us, which is why there is a way to interpret this statute and address some of these concerns while making it inclusive of queer communities and without excluding or eliminating any of the protections already built in.
One of the main concerns that I believe that the center had while this entire matter was going on was that this doesn't really fall under the ambit of the powers of a court to go ahead and do something like this. It should instead be handed over to the parliament to make an appropriate law at a time that they think fit. So what is your response to that?
I would say that there is no lawmaking involved here. The law already exists. It's called the Special Marriage Act. It was made in the 1950s. The question is, can a law pick and choose and grant rights to some people and not to others? Because it has to pass the equality test of the Constitution. And therefore, our argument is that the forum that can decide that is not the parliament. You have the right to pass laws, which you've done. Now it is for the Supreme Court to assess the validity of the law, especially with an evolving constitution that has evolved post the privacy judgment in Puttaswamy, post the Navtej Johar judgment in that decriminalized 377, that therefore this is in fact the right forum. In fact, I would argue that the court would not be discharging its function of scrutinizing laws or whether they pass the rigors of the Constitution if they didn't take up this litigation.
I see queer persons, lesbian, gay, queer people, transgender people, intersex people, asexual people as citizens of this country. As citizens of this country, as human beings on this planet, we all come with certain rights. We shall see whether the court recognizes the right to marry, the right to choose the person that we love or not. Let us see what happens. We have worked very hard. The struggle has been there for a long time.
Yes. Anisha, give us a sense of what has been by far said by the government in the court when it comes to legalizing same-sex marriages. What has been their contention?
I'm sorry, Sneha, can you repeat the question?
Anisha, yes, Anisha, my question to you was about the government's own position when it comes to same-sex marriages. They've been opposing this. What exactly has the government said in a court of law?
Well, see, the government stand in this petition has been twofold. One, that society does not accept it, and two, that it requires a change in multiple laws, which is something that is outside the jurisdiction of the Supreme Court itself. Thirdly, what the centre had suggested, and this is something that happened during the hearing, is that, well, we can put together a committee of sorts, possibly including the Chief Secretary and other senior officials of the government, to see what kind of rights can be given without giving the full status of marriage. These were the 3 points that the government had raised before the Supreme Court during this hearing. At the same time, however, we also saw the petitioners' stance. The petitioners were saying that this is not about one point or the other point or giving partial rights. It is about recognizing the fact that these are valid relationships, that these are people who are adults in a relationship that they are choosing to be in, and therefore giving them all the rights that any heterosexual couple in this country has been given, including the right to live with dignity, including the right to choice. And in fact, if the country can give rights co-equal to marriage to a live-in couple, then why not give the same rights to LGBT couples as well? Those are the 2 lines of argument really we've seen in the Supreme Court, Sneha, and we'll have to see, as Nalini just pointed out, how the Supreme Court is going to balance these out, because the court will have to see what the letter of the law, what the actual text of the laws says. Even under the SMA, the opposition that the government had put in was the SMA provisions specifically say that there has to be a man whose age of marriage is given separately, a woman whose age of marriage is different. There also are provisions in the SMA itself which are looking at prohibited degrees of relationship, which is defined under the Hindu marriage. laws as far as the country's definitions of prohibited degrees of relationship are concerned. So there are going to be various nuances, there are going to be various issues that the Supreme Court will have to consider when it is passing this judgment, because while it has to protect the rights of these persons, while it has to protect the life and dignity and choice of these persons, it will also have to see how far can the Supreme Court by itself interpret the letter of the law. The most contentious point and the sticking point really, which is where the judgment will have to be very, very nuanced, is the fact that for the SMA, that is the Special Marriage Act, defines marriage between a man and a woman.
Okay.
Now, the court during the arguments had given the observation that you cannot have this kind of a stricto sensu gendered role.
Okay.
But what that will translate into the judgment is something that's going to be crucial to see.